Hello, good morning, good afternoon, or good evening, and welcome to the NRC Tech Talk on the pre-application process with the NRC. Before we get started, I'm just going to go over a few items so that you know how to participate in today's event. For the best experience, please turn off any VPN connections or Citrix connections. And please, you can submit questions at any time by typing them into the questions section of the control panel. You can also send those at any time during the presentation. We'll address them during the Q&A session. If you have any technical issues, please email Cheyenne Odenthal. Her email address will be in the chat section of the control panel. And for any programmatic questions, please send an email to nric@inl.gov. This event will be recorded and it'll be provided on the NRC website afterwards if you miss any portion of it, or if you know of someone who was unable to attend but would like to see it. And now I'm just going to give a little bit of background on the event. I'm excited about this one for a variety of reasons. For those of you who have joined our previous regulatory tech talk, thank you for joining again. And for those of you who haven't, I want to explain the purpose of these tech talks a little bit, just to set expectations and help you understand what our goals are. What we're doing here is trying to have a short, relatively informal event that helps us address topics that have received a lot of questions. So there are topics on which we've spoken with folks at the NRC, and they have various inquiries about the pre-application process. And we know that there are folks in the industry and among innovators who have questions about the pre-application process. The idea here is that we want to promote open exchange of information in a forum that will allow fuller participation from the innovators who have questions, as well as allow the NRC to really prepare and have multiple staff available to answer questions. And we have about 100 folks registered today, about 48 people on right now, it looks like. So you can see that I think we're achieving our goal. Instead of a lot of one-on-one meetings to talk about pre-application, we've now got a few NRC folks and 50 others. So I hope that this will be helpful and really efficient as well. Pre-application in particular, we've heard the NRC emphasize over many years now how important and helpful pre-application can be in the NRC application process, and I've heard that a lot. I've also heard a lot of folks from industry not sure how to go through the pre-application process and get the most out of it. And that's really what we'll hear today from the NRC, and you'll have an opportunity to ask questions, is how do you get the most out of that pre-application process? How do you make it as effective and efficient as possible? So I'm looking forward to hearing our speakers, and now I'll go ahead and introduce our speaker and our panelists for today's event. So our speaker for today is Mr. Adrian Muñiz. He is currently a licensing project manager in the Division of Advanced Reactor and Non-Power Production and Utilization Facilities in the Office of Nuclear Reactor Regulation. Mr. Muñiz joined the U.S. Nuclear Regulatory Commission in 2003 as a project engineer in the Division of Licensing Project Management in the NRR office. After obtaining his licensing project manager qualification, he served as the project manager for several operating nuclear plants. In 2007, he joined the Office of New Reactors, or NRO, and while in NRO, he served as the lead project manager for the reviews of the Fermi 3 combined license application and the Advanced Boiling Water Reactor Design Certification Renewal. Our additional panelists for today are Timothy Dreswicki, who's a reactor systems engineer in the Advanced Reactor Technical Branch in the Office of Nuclear Reactor Regulation, as well as Ian Young, who's a senior reliability and risk analyst in Advanced Reactor Technical Branch in the Office of Nuclear Reactor Regulation, and then Jack Cushing, who is the senior environmental project manager. And now I'll turn it over so that you can hear from Mr. Adrian Muñiz about the pre-application process with the NRC. Please go ahead, Adrian.
Thank you, Ashley. So in the interest of conserving some bandwidth here, I'm gonna stop sharing my webcam and I'll initiate my discussion. So I'm here today to essentially discuss the NRC's draft white paper on pre-application engagement to optimize advanced reactor reviews. I should note that a new version of this white paper was issued actually yesterday, and it can be found in Adams accession number ML21145A106. I did provide this paper though via email to the INL, and I think they're going to be making it available after the presentation today, but also feel free to access it through Adams through the accession number I provided. So this paper lays out a voluntary, robust pre-application program that essentially advanced reactors could choose to implement in order to optimize application reviews. That's essentially what this white paper is about. Next slide, please. So as was pointed out before, the encouragement from the NRC to engage in pre-application engagement to prospective applicants is not new. We've always encouraged that because we believe that it leads to more efficient and effective reviews because it facilitates early issue identification and resolution. Now, the paper itself, it provides information to advanced reactor developers regarding the benefits of the robust pre-application engagement that is laid out in the white paper itself. It encourages in order to provide stability and predictability in the licensing process because you are then identifying issues early prior to your application being submitted. And then leads to resolution of those technical and policy issues. And I'll expand upon it a little bit more later, but how you go about that is through technical issues are resolved through topical reports in which you obtain NRC's review and approval. And regarding policy issues, you are essentially engaging with the NRC to identify those matters that raise to the level of a policy matter, so that one, for awareness, and two, so that the NRC can engage on those and try to resolve them. So the paper also proposes a set of pre-application activities. So these are key items that we have identified through our experience doing application reviews that we believe that if fully executed during the pre-application activity will enable the NRC to then offer in return to the applicants more predictable and shorter schedules, as well as other benefits. And I will discuss that in the next slide. So you could move on to the next. As I said before, pre-application engagement results in enhanced predictability and greater review efficiency because of the early resolution and of technical and policy issues that could affect licensing. In addition, by tackling specific issues, it provides for more visibility on key topics and how they are addressed. And that is from one, the standpoint of the staff and the applicant, because we are essentially working on, I will say, carved out specific key elements of your design, and we're addressing those, one, in advance of the application, but also specific to those issues. And it allows also for more visibility of members of the public that are following the discussions through the pre-application activities, so they can see how key elements of your design are being addressed. In addition, by bringing forward those specific issues during pre-application that allow us to engage with ACRS and other agencies on key topics that would otherwise will have to be handled during the review of the application, and in some cases challenge or even affect review schedules. And in case you don't know, during the if you were not to engage in pre-application reviews, we still are for any of the licensing application products, if you will, we do engage with ACRS on these topics during your application review. So by addressing and engaging with ACRS even prior to the application, we can put these items forward in front of ACRS, and so that when the time comes for your application to then be reviewed through ACRS, they're already aware, they already had a chance to weigh in on some of your design aspects of your proposed facility. So next slide, please. Now, more specific in terms of what do you gain other than the benefits that I already alluded to in the previous slide? Well, what we're saying is, because we went through a comprehensive look using our experience in licensing as to what are the key elements, both from a safety review and environmental review, what are those matters that are key. We are saying if you, as a vendor, execute all the activities laid out in the paper, it will allow the staff to offer review schedules that are at least 6 months shorter than the generic schedules that we have identified as part of the NEMA for the different licensing actions, such as COLs and DCs. And you can find those generic schedules in our public website. In addition to offering this 6 months shorter than the generic schedules, it would allow us as well to conduct an acceptance review, which we are required to do in order to docket your application, in as little as 2 weeks, since we will only be limiting that review to administrative aspects of the such an action, such as conducting a proprietary review and making the application publicly available. And what that allows us to do is all these activities that you have done, as well as a pre-application readiness assessment that I will discuss later in the slides. Now, in order for us to be able to maintain and achieve this schedule that we will be able to offer to you due to your pre-application engagement, applicants will have to, though, one, as part of the request for additional information process during the review of your application, be timely in your responses to those requests for additional information. Also, you should not be making substantive changes to the application after it has been docketed, meaning design changes that are substantial. And lastly, not make any significant design changes from the application to the application, meaning if you had put forward a specific element of your design, such as, for example, fuel, and that has been reviewed and approved through a topical report in pre-application stage, you should not be making then significant changes to that when your application gets submitted or throughout the life of the application, because it would potentially impact that review schedule that we were able to offer to you. Now, next slide, please. So we, after taking into account those key specific areas of the licensing review, we then applied a graded approach to those items to identify the key safety and environmental licensing areas for application engagement. And using that graded approach, we identified the type of engagement that will result in the most efficient and effective approach. Therefore, you will see in the paper that for some activities, we identified things that need to be addressed through topical reports in order to support the definitive findings during the pre-application stage, while others we have identified as either submittal of white papers, audits, and meetings to obtain NRC staff feedback and for staff awareness. Next slide. For topical reports, the items that we identify are listed in this slide, and I'll expand a little bit upon each one here. So the first one being the principal design criteria that establishes the necessary design, fabrication, construction, testing, and performance of safety significant structure systems and components, or SSCs. For this one, we already have guidance out there for light water reactors in GDC in Appendix A to 10 CFR Part 50. And for non-light water reactors, we provided further guidance in Reg Guide 1.232 that provides guidance on how to develop PDCs and ensure the necessary safety functions and SSCs are covered under the selected PDC. The next item is that the applicant, again, and we're going through topical reports, and these are things that you submit to us for our approval. So I want to make a point here about topical reports. So the next one, we're indicating that you should request staff review and approval of your proposed process for selection of licensing basis events and classification of treatment of SSCs, or indicate that you plan to use an already approved process. We have already looked at the process described in NEI 1804 and how we have endorsed it. And further guidance on this can be found in Reg Guide 1.233, which is a guidance for a technology inclusive, risk informed, and performance-based methodology to inform the licensing basis and content of applications. On the next topic, for fuel, applicants need to be able to demonstrate that your fuel is qualified for use in your chosen reactor design or your proposed reactor design. Pre-application engagement on this area should include staff approval of the fuel qualification plan and associated methodologies, potential staff observation of the execution of the testing, and verification of the results of the testing to support qualification of the fuel. Moving on to the next item, regarding source term methodology, that should be developed by you, and it should include validation and verification of associated engineering computer programs. The source term development should include things as radiological source term for effluents, rat waste system design, shielding design, and equipment qualification. Regarding the quality assurance, what we're asking applicants in order to get the full benefits of laid out in the paper is that a quality assurance program description topical report should be submitted to the NRC in the pre-application phase to ensure that your design and the application that you're developing and that will be submitted to the NRC is being developed in accordance with Appendix B to 10 CFR Part 50. Regarding the safeguards information plan, by you having an SGI plan that is approved by the NRC, and this one, actually, it allows us to then share with you, once you have an SGI plan that has been approved, share with you information that you should consider regarding safeguards and security in the design of the facility, pertaining to physical protection of plants and materials and the aircraft impact assessment as required in 10 CFR 5150 for the aircraft impact assessment. Regarding safety and accident analysis, these should include testing of applicable SSCs and validation and verification of associated engineering computer programs. You should note that 10 CFR 50.43E requires applicants to demonstrate that sufficient data exists on the safety features of the design to assess the analytical tools used for safety analysis over a sufficient range of normal operating conditions, transient conditions, and specified accident sequences. Next slide, please. So now we come up on the meetings, audits, and white papers. And I want to stress out here that while with these you're not getting approval.
Adrian, I'm sorry, we haven't moved on to the next slide yet. Could we get
Oh,
this?
I'm sorry.
Thank you.
Thank you so much, Tim. Are we there yet?
Yep, ready to go.
Thank you. Yeah. Thank you. So on this slide, these are topics that are that we're proposing to be dealt with meeting, audits, and white papers. In that, if you recall in the previous slide, I indicated that in here, these are products and engagements that are used to obtain feedback from the staff, but also to make the staff aware of different things. And I'll go through the specifics now. So the first item being a PRA review, what we're proposing here is that the prospective applicants should facilitate NRC staff's audit of the PRA peer review prior to submitting an application, and should explain to the staff how the PRA will be used to support your application to determine the acceptability of the PRA for its plant use. It should describe the development of the PRA, highlight the use of any approaches that differ significantly from endorsed consensus standards and NRC staff approved guidance. In addition, a regulatory gap analysis report should be submitted, going to the next bullet here, listing those 10 CFR Part 50 or Part 52 requirements for which an applicant plans to request an exemption. And I will note that we have developed white papers in this area already, that if you want, I can maybe provide after the meeting as a reference document that you can look at. And in addition, we've provided feedback already to some applicants in this area. Then I will say on the next topic regarding policy matters, it's really important that you engage the NRC as early as possible on items that could be policy issues that need to be brought forward to the commission for a decision. And in some cases, it might be a little bit difficult to determine what is a policy issue. I think in this area in particular, becomes really important that you, my suggestion, talk frequently with the NRC staff. I will venture to say, familiarization meetings with the staff where you present your design, key aspects of your design may allow and support identification of what could be considered policy issues. And also, if there's anything within your design that you are not quite sure about whether it falls within this category, I would just say, having that open dialogue with the NRC, having that discussion will flush them out and determine whether that is something that falls within this bin, if you will. Similarly, on novel design features, and these are things like, for example, a passive system, like a passive cooling system, or an inherent safety feature of your design, maybe a simplified control feature that is within your design, could be a novel design feature, should be discussed with the staff through either white papers or meeting to allow for staff familiarization with those novel design features, so that we can develop a review strategy and review guidance for those if needed. During the pre-application stage, the prospective applicants should also use Whitepaper to identify any consensus standards and or code cases that you intend to use, and specifically, maybe to some extent more important, identify any standards or code cases that have not been endorsed or previously accepted by the staff. Regarding environmental review matters, it's kind of a combination of white papers and meetings that should be used in order to identify things like novel environmental methodology or issue, discuss the site selection process, access to cooling waters and approvals from relevant permitting authorities, and status of needed authorizations, permits, and approvals for the project. Furthermore, early discussions in areas such as socioeconomic characteristics of the community, aquatic or terrestrial ecology studies that have been performed, federal listed species and potential impacts, as well as historic properties, will be areas that the environmental review staff has identified as matters that have become controversial in some cases affecting the review schedule. So again, having those discussions early would allow us to develop a strategy and allow us to provide you feedback on things like pointing out permitting that we've seen needed before, either with state agencies or otherwise, that you should be engaging on potentially separate from your licensing activities with the NRC, but that ultimately support the licensing of your facility. So moving on to the last slide, as a final point in the paper, and I alluded to this prior when I was talking about the 2-week timeline for acceptance review of your application, but also it feeds into the NRC confirming that what we've seen in your pre-application still holds true for what the application that we're about to receive. We are indicating that a pre-application readiness assessment should be conducted 6 months prior to the application submittal date. We do have an office instruction on this. It is cited in the paper with an Adams accession number, so I suggest that you can pick it up and read it and see if that it makes sense to you. As part of this pre-application engagement, you will be providing to us to support this assessment the most current draft of the safety analysis report and environmental report, reference documentation in these reports, as well as access to your staff and contractors in order to support discussions with the staff as to any questions we may have during the assessment itself. We will take into account the type of application that you're intending to submit and the extent of pre-application activities that you have engaged on in determining the scope of the readiness assessment itself. So I will then want to make a last point here, kind of an overall point here. One, like we stated before, we encourage pre-application activities. We've came up with this voluntary program that is fully executed. We are giving you some things here in return, like shorter schedules and shorter acceptance review. Having said that, one, it is voluntary, but I will say if for some reason you can't not do all the things that are laid out in the paper from a pre-application standpoint, I will still urge you to engage in pre-application engagement with the NRC to the best of your ability. I think it is something that it helps with the application review in making it more efficient and effective. So with that, I will stop here, and I think we can then open it up for questions.
Adrian, thank you so much for your presentation. It was very detailed. For the audience, if you want to drop any questions in the chat, I can just read them for the whole group, and the NRC panel can answer them accordingly. So in regards to your closing remarks, Adrian, I wanted to ask in respect to some of the innovators budgeting, when do companies have to start paying NRC fees for the pre-application interactions?
Excuse me. So for pre-application interactions, they do get billed to applicants because we are conducting a specific review to your application. Now, for things as, let's say a vendor applicant has generic questions about our requirements, for example, that they wanted to engage with us and understand our requirements. Those are not billed. It's when you are having something that you want reviewed and assessed against our requirements that specifically support your eventual license application. Like, let's say it's a white paper that you put in front of us, a topical report that you put in front of us for review, or something that I will call directly supports the licensing of your facility. I will always say, if for some reason there's questions about whether an activity is feasible or not, you will just be in contact with a licensing project manager, and you can ask those questions if any specific questions pertaining to your specific circumstances arise in this area.
Perfect, thank you. Regarding the pre-application readiness assessment that you mentioned on that titled slide, it's identified that 6 months before the submittal date is when the readiness assessment should be submitted. Can you kind of walk through some of the innovators, how final that document should be, and how do they kind of balance that pre-application readiness assessment with their application for NRC licensing?
So yeah, thank you for that question. So I would say, if I was doing this and I wanted to engage in the activities laid out in the paper as I indicated, I would start looking at those activities now, all of them, including the pre-application readiness assessment, and come up with a plan that supports your eventual submittal of an application, just so that you can support the timelines laid out here. And I would even venture to say that you should engage with the NRC staff on your proposed timeline of engagement, if you will, to ensure that it supports what your plans are for licensing. Matter of fact, prospective applicants have engaged in such activities, not necessarily to the extent of what's laid out in the paper, but they have communicated to us the expected pre-application engagement that they want to engage on with us, the different activities, whether it be topical reports or meetings, in using a document referred to as a regulatory engagement plan. And what that allows us to do is for applicants to put their plan in front of the NRC and discuss it with us and obtain another vehicle, if you will, for feedback on their plan engagement with the NRC. So I would say that will be my answer there. And then on the pre-application readiness assessment itself, having a good communication with the PM as to the activities that support that readiness assessment is key. Understand this, the more you do in terms of prior to even the readiness assessment itself, in terms of communicating, obtaining NRC staff feedback, obtaining those approvals that I alluded to in the paper, then when you come to the application readiness assessment, we're essentially just checking that those understanding, those feedback, those approvals are still valid in terms of or taking into account the what we're seeing in this draft document, final safety, the draft safety analysis report, which is essentially your application that you're going to be submitting. So I would venture to say that 6 months prior to your application submittal, you probably have a really good draft version of those documents that can support those discussions with the NRC staff.
Thank you, Adrian. Moving on, I just wanted to talk about exemptions and departures during pre-application interactions. How much certainty can applicants get from the NRC during those interactions before they submit exemptions, and what regulations apply?
So what the applicants have done for their designs, they have submitted this gap analysis documents through white papers to the NRC, and they have obtained feedback from the NRC as to whether so it will be an assessment from you first, indicating, we believe the requirement in regulation X either applies to us and we are going to comply with it, and we'll demonstrate that in the application, where others, you will note this requirement does not apply to us, and it doesn't apply because certain design feature that you may have or design element, and you will explain that. In others, you will say it's applicable, but we are going to be providing an exemption request, and that will allow us to give you some high-level feedback at that point. Having said that, what drives what I will call the approval of the exemption is the actual exemption request itself, and not the communication about what you believe are the requirements that are applicable to your design. And I pointed out before that we've been going through some efforts at the generic level on identifying those requirements that are applicable to non-LWRs. And what I could do is I could provide that whatever documents we have right now after the seminar, so you can distribute with the people that were involved in this seminar after the seminar.
Wonderful. We can definitely get all those resources out. I did want to give Ian, Tim, and Jack an opportunity to chime in if they had any comments thus far before moving on to the next question.
So I just wanted to say one thing that I was involved in is as far as the new scale review, and this is kind of add on to what Adrian did, is we had gone through a period in which they had submitted how their design was going to meet certain regulations, or how it would meet them in a different way, and we gave them feedback there, and that may be a worthwhile thing for people to look at, to see how he responded, to look at the type of language that was used, because in terms of finality of stuff or decisions made in those letters, it is somewhat tentative, and so the language usually is not final in there, because we don't have the actual design, and so you would see some of that in the language. And I could I could send the link out in the chat if that would help.
Thank you, Tim. I had a question from the audience regarding what are the major milestones you must achieve before starting your application?
So are you talking from a regulatory perspective? Because I will see, I think maturity of the design is I think really important. I would say for pre-application engagement, you know, having discussions early might help you with finalizing or at least taking into account regulatory feedback in making design decisions, if you will, or the final design decision prior to submittal. But I don't think that there is a necessarily a the more finalized for a given topic you are, the more I will call it solid feedback you may get, or even approval if it's done through a topical report approach. And that's why again we took that into account when we were when I alluded to us making decisions. Okay, these are key topics, but within these key topics, which ones are what I will say supportive of us being able to make conclusive findings through topical reports during the pre-application stage, and which ones lend themselves more to support discussions and getting early feedback and awareness to the staff to determining whether additional actions need to be taken to support the eventual review of said application.
Perfect. I think the next one is kind of in line with some of the design questions, and it's in regards to quality control. Regarding pre-application, are you looking at a high level, or does the NRC really dive into some of the quality analysis during the pre-application audit process?
So from a quality assurance perspective, what we've indicated is having a quality assurance program description submitted through a topical report and approved prior to the application coming in was found to be a key element to have, as is, because then you have a plan that has already been found to be consistent with our Appendix B to Part 50. What we would do is, once you're let's say you submit such a document and we approve it. Once the application comes in itself, what the technical staff in charge of that element of the review will be doing is conducting an inspection to ensure that you are implementing that approved plan in accordance with essentially the plan that you provided to us. And so we believe that applying quality, whether it be because, and I'm exiting a little bit here, the white paper itself, because as I said before, we are strongly suggesting that you do come in with a topical report prior. But let's say you don't. I think you applying a quality assurance program and plan through, for example, collection of data and all that information will prove to be useful later in the application to be able to stand behind or support the data and underlying analysis that support your safety case.
Perfect, thank you. And this is a question in regards to encouraging more pre-application activities. Are applicants protected under 10 CFR 2390? I'm sorry. So does that cover their intellectual property during the pre-application activities?
Yes, it does. So you will have obviously to submit an affidavit under the provisions under 10 CFR 2.390, attesting that the information you're providing is commercial in nature, and it carries some requirements about, you know, the protection of such information, and attesting in an affidavit as to the harm that will cause to your company should such information be released to the public. Having said that, you know, we will review your assessment, and we will make a determination, and we will weigh in, you know, we will try to, if we identify any issues, we will be, you know, discussing it with the applicant, to one, either convince ourselves that such information is actually what we refer to as proprietary or commercial sensitive, or in the case that it is not, we will have those communications with you. But the short answer is yes, you are protected by those provisions as long as you submit information that supports the meeting the requirements under that regulation.
Perfect. I know you mentioned this in your presentation, but I wanted to dive into some of the novel features or design features that are mentioned in the white paper. Could you kind of dive into some more examples as to what kind of design features the NRC is particularly interested in during the pre-application process?
So novel issues, I think I alluded a little bit about it, but it could be, and I'll ask maybe the staff to add others if they can think of, and I think you're asking for specific ones. Like, let's say some kind of passive cooling system that you'll be using. Another novel design, maybe, I guess I'm thinking the fact that maybe your design demonstrate that the shutdown mechanism doesn't have to be safety related, could be something to discuss with the staff. I don't know if that ends up being novel, but again, like I alluded before, anytime you're not quite sure about something, I will put it that way, I would just suggest having a discussion with the staff, because it leads to, again, early identification of issues and resolution of those issues. Even if it's to say, no, it's not quite a concern, we've seen it before, and so we don't need to take further action. But I'll leave now, open it here for maybe Tim or Ian to see if maybe they have other examples.
Okay. Thanks, Adrian. And yeah, so I just want to highlight that that's, you know, obviously for things that are going to have an impact on safety. So one thing, you know, that's going to fall in there is fuel and, you know, fuel qualification. So if you're going to use, you know, a fuel, a design that is, you know, much different from what we see in light water reactors, you know, we're probably going to want to see, you know, some kind of evidence in terms of the fuel qualification. But I think it's important to know what your safety case is and what systems that you're relying on and how they're going to function to support your safety case. And so that may be something, you know, say, for example, some kind of instrumentation in, you know, like your INC system. So if you're going to rely on, you know, your plant's ability to detect adverse conditions and to shut down, you know, it's important that you can point to an, you know, experience base to show, you know, to give you confidence that's going to function. And then there's also systems, you know, as far as, you know, like a lot of passive systems. That rule kind of came to be, that language. It's important. I think that came up in like the mid 90s where that was added into 5043. And there's a lot of stuff going on in the area of, you know, advanced light water reactors then. So if that gives you any context.
Adrian, this is Ian. If I can just add a couple of additional information, and In terms of definition of novel and unique design features, and there are some subjective interpretation of that, and some of the non-light water reactor designs go way back, and there might be some areas that, hey, we do have experience and so on. So that subjectivity could be something that can be also discussed. And as it's applicable to, as Tim mentioned, about 5043E requirements. But I think broadly, some of these new and different designs, clearly the staff members are, some of them at least, are not familiar with it. So pre-application engagement would help the staff to understand, and during the pre-application interaction, there could be opportunities to provide a meaningful feedback to the potential applicants as they bring up those designs, and also mutually, agree upon potential path forward on whether topic reports or white papers or and so on. So I just wanted to share that.
I agree with you, with both of you, Tim and Ian, and I think that's why I think I alluded maybe in passing before, having maybe what I would call design familiarization meetings with the staff, where you come in and you spend some time with the staff, going over what you believe are the key attributes of your design from a safety perspective. That could go a long ways.
Thanks for all your feedback. I have time for one more. And actually, I just got one from the panel. Question might be irrelevant, but just wanted to ask if you had planned for a combined license application. Is it worthy to apply for an early site permit? Does it change anything? How does the NRC staff consider this?
So, so think of it. So I will say this: early site permits, you will be able to, again, put in front of the NRC an area of the design from a site characteristic perspective that will get a review and approve, and then it will support a combined license application itself. In that, then those matters are already resolved for the COL, and they don't need to be revisited, if you will. But I will say this: the different licensing, I'll call it products, out there, I will say that vendors should look at them in view of your commercialization or deployment plans, and determine which ones or combination of would support such deployment plans, and lay out a strategy that makes sense to your specific circumstances, both from supporting your deployment plans, but also from the standpoint of, I will call it, regulatory feedback, regulatory decision on certain aspects of your design. Because just as you could go with an early site permit, you could decide also to go through either a standard design approval or a design certification application. So I will say, take into account those regulatory products, whether it be under Part 52 or under Part 50 SCP-OL approach, and see which ones or combination of make sense for your deployment plans.
Wonderful. I want to just take the opportunity to personally thank the panel and for answering all of our questions and remarks. I'm going to turn it over to Ashley for closing remarks.
Great, thank you, Stephen. And I'll be brief here. I hope that this was useful. I certainly found it very useful and interesting, and look forward to seeing that white paper that was discussed. But I appreciate very much Mr. Muñiz giving us the presentation on the pre-application process, as well as the participation of Mr. Dreswicki, Mr. Young, and Mr. Cushing on the panel and helping to answer questions. And finally, thanks to all of the audience members for joining, and all of the folks who helped make this possible by putting on the webinar and organizing from both NRC and from NRC and INL. Again, thanks very much, and we appreciate your time. This will be recorded and available on the NRC website. Have a great day.